All right, peace, family. This is Dayvon Love, Director of Public Policy, Leaders of a Beautiful Struggle. I'm here with my man, Lawrence Grandpre, Director of Research, Leaders of a Beautiful Struggle. Want to thank you all for coming out to hear what we got to say about the Maryland General Assembly. We're going to focus pretty extensively on the issue of policing in the Maryland General Assembly. There's a lot to talk about. It's one of the major issues that's being dealt with in the Maryland General Assembly. And it's also a major issue for us as an organization. We focus on policing for many years. It's something that's important as a matter of policy. And so we're going to spend a lot of time talking about that this evening. We're going to weave in conversations just generally about policing, but also get some updates legislatively about where things are in the legislature. There's a lot of just kind of fine details, a lot of really kind of nuanced conversation. And so that's why we felt it made sense, particularly at this point in session, to spend an entire podcast from Streets to the Statehouse to talk about that. Again, this is Streets to the Statehouse. It's brought to you by Leaders of a Beautiful Struggle. We're an independent Black grassroots organization. I'm committed to improving the quality of life of Black people. And that's the perspective that we're going to bring. And that's actually going to be particularly important in the conversation we have today, because we're actually going to spend a lot of time at the top talking about just our general frame as to how we see the issue of policing. And so what I want to do first is just lay out just some general context, and then Lawrence, just get some of your thoughts on just the importance of this framing when we talk about policing. So one of the things that I know I've been really frustrated with when we think about policing, an issue that's become a mainstream issue, we see, police brutality, events of police, violence being rendered a major spectacle. Mm-hmm. And so a lot of the way that media and television has covered policing is one that is rooted in this notion of focusing so much on the spectacle of Black violence and suffering, and has focused on pleas to the white mainstream to recognize Black suffering and to recognize Black people's humanity. And this is something that is just, as a matter of a big picture framing, is something that's been really core to our advocacy. So before we jump into, go into some of the specific details, if you can just give some thoughts on just that as a conceptual frame and how ubiquitous that, because we talk about this a lot, of how ubiquitous that frame is.
So I think about it a lot to how people are taught American history. So when I think about how people are taught the civil rights movement, the joke is amongst certain people who have studied it, the joke is what America teaches you is that Rosa sat down, Martin stood up, and the white people saw the light and saved the day. Mm-hmm. And a lot of us who are, read and analyze and understand it's way more complicated than that. But a lot of people genuinely believe that. They genuinely believe that what happened in the 60s was a recognition of the plight of Black suffering, and that the way for us to make concrete political gains is to just demonstrate how down bad we are and force people to recognize it. They talk about the fire hoses and seeing people get fire hosed, when in reality, what caused change was veterans coming home for the Korean War, segregation outliving its usefulness, and the Cold War creating a context where it was in the best interest to grant strategic concessions. So that complexity, and also just the decades of grassroots organizing in the South dealing with things like the rape of Black women by white men, that laid the groundwork for that community organizing. All that gets erased when you focus on the spectacle on TV and assume that was the impetus for the change. I think something very similar is happening with policing. But the assumption is that the big protests and the Ferguson, that was the impetus for meaningful reforms and people seeing things like consent decrees as meaningful reforms. When in reality, we know policing is not a federal issue in terms of federal consent decrees. It's a state and local issue. And in many ways, they have been, as we're talking about, very slow. And they feel they can get away with it because they're using the mythology of these strategic concessions that look radical, but don't really change the power structure, to buy them time to maintain the power structure that allows them to continue to use this as a system.
And so just to talk about how this played out. So when I think back to 2015 and 2016, because I remember, the Ferguson uprising happened August 2014. And so then, Maryland's General Assembly is January to April, beginning of April. And so when we came back to session January 2015, I remember there being a whole bunch of bills relating to police accountability. Now, one of the things that's often really frustrating, particularly those of us that have been really on the ground addressing the issue, and folks who are not swayed by or who don't center the national trends. There was Christopher Brown in Baltimore County in 2012. There was Tyrone West in July of 2013. Yeah, Anthony Anderson. So there were a variety of folks, around that period of time when, we worked on Christopher's Law with then Delegate now Senator Joe Carter and the Brown family. And so I remember coming back into session 2015, you had body camera bills, bills about training, even though we had just passed one because that's what Christopher's Law was, bills about mental health screening for police officers, bills about the local hiring, bills about like an independent investigation. And the thing that was always kind of at the bottom of the conversation was things that would empower the community to exercise power over law enforcement. The way I used to put it is that people would sit around watching too much MSNBC, you know what I'm saying? And then just, legislating what they saw on television. And so that's actually a part of what I think we're dealing with now. We're dealing with now a context where a lot of conversations on chokeholds, conversations on body cameras, conversations on training, de-escalation. None of these things, which are inherently bad, but very rarely a focus on conversation about giving the community power as the centerpiece for what police accountability work should be. And that's particularly important because one of the things that I think is coded into that is that I think for many people, the idea of giving Black people power is it's like off the map of possibility politically, because all of the tropes that are projected onto Black people in terms of anti-Black notions of being inherently corrupt or being inherently incompetent, which aren't things that get projected onto law enforcement, even though it certainly makes sense. It's certainly a sensible, characterization of law enforcement, given how much money they get, how ineffective they are. And so, I think we're in a moment now where that frame, the frame that you and I are criticizing, has shown its limits. And I think a part of the importance of our perspective is about the importance of, empowering Black people. One other thing that I think adds to the difficulty, and again, this is something you and I have talked about, and I'm interested in you kind of expanding on this, is that police occupy a place in the American imagination, more so in the white American imagination, that distinctly is at odds with the reality that Black people live. Like when I'm testifying in committees in Annapolis or listening to work sessions in Annapolis, particularly some of the Republican legislators, which, they don't have a lot of power in Annapolis, but certainly, have a voice. I hear just such a stark contrast between how society views law enforcement and what our lived reality is. And one of the barriers that it places in terms of dealing with police accountability is that it is almost like our claims as the level of corruption and anti-Black violence that police levy on the community are understood to just be an agenda or propaganda, as opposed to it be, at this point, we now have a bunch of empirical evidence of this level of violence, but it's still treated as something that's an agenda as opposed to the reality that we live. So you talk a little bit about just some of, your thoughts around just this place that police occupy in our collective imagination and that being a roadblock.
Yeah, I mean, sometimes I make it an impetus to talk about one thing that I feel is oftentimes, Michelle Alexander said it, that it's one of the things that's least quoted of hers. I think it's one of the most important things that should be the most quoted. It's a flaw to understand that the system is working. The system is working exactly how people have set it up to. Policing is using all this public money because people have chosen to invest in this system of control as an investment in the psychic stability of a certain class of people, property, moneyed people. And I think that when you have defined police in this way, the CSI mythology, and always assuming that if cops weren't there, there would be this uprising of violence from the Black underclasses, anything they do in a lot of people's minds is always better than what they assume the alternative is, which is rampant crime, rampant violence. We know that policing levels are not correlated with crime declines. We know that the war on drugs when you talk to cops, I mean, my family is full of cops. When you talk to them, they say the war on drugs has taught multiple generations of cops how to not do the job. So cops aren't really as good at investigating crimes. We know that cops are very selective on the resources they dedicate to solving witch crimes. So we know a lot of these mythologies just aren't true. But because there is this need to envision the possibility of this virtuous entity protecting your family and your community, so much of just the lived reality of what policing has become is just moved beyond the space of debate. And you're stuff debating a mythology as opposed to reality.
Mm-hmm. So another kind of framing thing, and then we'll just jump into some of the specifics of the bill. Because I think one of the mistakes that get made, there's some folks in the legislature, for whom I respect as people and legislators, but in terms of their worldview and frame, are rooted in the status quo that you and I have kind of characterized, right? And, one of the things that, is generally important is people's ability to make distinctions. And, because again, there are lots of folks that are going to talk, pretty adamantly about, addressing chokeholds, body cameras, training, mental health screenings for police officers, things like that. And, for us, one of the things that is different in terms of the way that we approach legislation, and it goes back to kind of what you said about the civil rights movement, is that as folks who have what we would describe as kind of a Pan-African nationalist lens that sees the sovereignty of people of African descent as kind of the ultimate pathway to freedom for Black people, then the way we approach this legislation is about creating mechanisms legislatively that give the community power, which is different from how some folks think about legislation, which is the state fixing the problem, the state developing a process or a body that it goes in and fixes the problem. And that's a really fundamentally different approach, which goes back to the conversation we had a few moments ago about the notion of giving Black people power is kind of off the map of possibility for many folks because of how it's represented. One of the things I know you and I've talked about, and if you could expand a little bit on this, when you think about the civil rights movement and the way in which the federal government was romanticized as the savior of Black folks, and that the primary, because I think that gets replicated in state government in terms of traditional approaches to legislation, where, the state is supposed to come in to a jurisdiction and it's supposed to provide a mechanism to fix the problem, as opposed to saying, let's create mechanisms by which the community can exercise its own power.
Yeah. And I would say one of the most difficult to dislodge mythologies about the civil rights movement is the role of sort of which Black people, Black elites, especially lawyers. So this is I would describe part of the distinction between opening space for top-down enforcement versus opening space for bottom-up enforcement. So we're taught with the civil rights movement that was essentially a top-down mechanism that produced most of the change. Brown v. Board, lawyers, Step Up, Thurgood Marshall, Supreme Court, and these sort of elite power brokers in D.C. stepping in, brokering these compromises, and then those subsequently being enforced through different court cases. So protecting affirmative action from being rolled back. And a very similar thing is happening in how people design policy at the state level, in terms of they want to open space maybe for a certain sort of top-down elites to be able to be the enforcement mechanism for what they see as the change happening. So we saw this in some iterations in past bills where they would let's have an administrative law judge come in and be the person who protects you from the evil trial board. When that's just another lawyer that's paid for by the government, that's not actual grassroots people on the ground collectively organizing their power and leveraging political consequences. I think there is an assumption that either people don't see it or they don't believe it. People can be lulled into the illusion that you can't trust people, regular people, to be smart enough to be able to interpret what's happening, and you can't trust them to be dedicated enough to be able to leverage their political power. Sometimes people even think, oh, they're so down bad, we can't expect them to enforce this law, so we need to recognize and protect them by doing it from the top down. When in actuality, if you understand power, you need to actually have mass politics on the ground to leverage political consequences. And that's the only way you have any enforcement mechanism. Because as long as you have that top-down framework, you're entirely subject to the capricious nature of the legal process, the capricious nature of elite power politics. The only check that can exist is bottom-up politics, and you need to have laws that open up space for that bottom-up politics to be that check.
Got it. So let's dig into the particular bill. So one of the things that we're focused on is the Maryland Law Enforcement Officer Bill of Rights, codified in 1974, and it is a state law that essentially is structured in such a way that it undermines the ability for the community to actually have powers of oversight and to be able to have the powers that you just described. So I'm going to lay out for a second just some of what we've been doing legislatively, the bill that we're kind of pushing in the Maryland General Assembly, and contrast it to some of the other things that have been proposed. So what has happened is that, the momentum from the social unrest from the summertime, and just much of the activity that has been happening over several months has created an environment where now the repeal of the Law Enforcement Officer Bill of Rights is imminent. And there are lots of folks that, should take credit for that. Those of us that have been working on this for years, people like Senator Carter, who's been on the issue for many years. Again, many of the families whose family members have been killed or brutalized by police. And then certainly Speaker Jones in the summer when, she called for the repeal of LEOBR, which was a big step for a presiding officer to call for the repeal of something that the Fraternal Order of Police is, for them is such an essential piece. So we understood the importance of repealing the LEOBR, but what became particularly important was developing replacement language. And the reason the replacement language was so important is because what we were concerned with, because after we had gotten a sense that the LEOBR repeal was going to happen, we had to sit and think about, well, what are some of the moves the FOP has? And one of the moves that they have at their disposal is to gin up their pressure to essentially establish collective bargaining agreements in each jurisdiction, such that they could have even more conservative, more restrictive provisions in their collective bargaining agreements that would even further marginalize, the community from having oversight and power over discipline. And so, the Maryland Coalition on Justice and Policing Accountability, which is a statewide coalition on policing that we've been involved with for the past several months, we, kind of a subset of us got together to develop the replacement language. And there are basically three major aspects of the replacement language that we've worked on that we think would be best. And so there are three parts of it. The first is one of the things that we thought made the most sense is moving away from trial boards. So for people who've been following our stuff for years know that one of the things that we've been advocating for a while was having civilians on trial boards. Now, it's important for people to know that there were two major things that we were pushing for in 2015 and 2016 around the whole notion of community empowerment, civilians on trial boards, and allowing for non-law enforcement to participate in the internal investigation of law enforcement. We wanted a mandate for civilians on trial boards in 2016. We were able to remove the prohibition, and then we didn't get the removing only sworn law enforcement and investigations. That was our advocacy then, because given the much more conservative nature of the legislature, we felt that was probably the most substantive thing we could get. But the problem with trial boards is that even if you have civilians in the trial boards, police still control the nature of the process itself.
Yeah.
So for us, and the whole notion of a trial doesn't quite make sense given the actual thing that's happening, right? Where it's the manager disciplining an employee for an infraction. So the idea of having an entire trial is a level of protection that most employees don't get. If you work for me, at Walgreens, you steal something, you don't get a trial to determine whether or not you get fired. That's rights that's usually reserved for, and then if there's a criminal procedure, that's an entirely different thing. So we are interested in moving away from trial boards, which in essence concentrates more power in police chiefs, with the rationale behind that being I can do more to a police chief than I can do to a rank and file officer, right? That we can, as a community, put pressure on the executive who appoints a police chief, or in jurisdictions who elect a sheriff. We can essentially put pressure on the chief, on the person that leads that agency, if they're doing things that the community doesn't like. This is why, and we won't talk a lot about this in this podcast, but this is why the advocacy on the Maryland Public Information Act complements this, because getting the information about the nature of how the police chief and management are disciplined police officers gives us the information we need, such that we can effectively put pressure with evidence about how they're running the department in terms of discipline to challenge police chief. So that's the first part. Second is a statewide standard on how discipline works. So one of the things that we were clear about, because there are lots of folks that will characterize, us and advocates for police accountability, it's like anti-police, right? Wanting to create a system where police are treated more harshly. And one of the things that we were clear about is that we wanted to make sure that police have due process commensurate to what you get if you're an employee of the government. And so what we've laid out is a procedure that allows an officer for whom is being given discipline to be able to confront the chief. There's a hearing process that's pre-discipline. That allows an officer to have the facts of their discipline be contested, and then the chief renders a decision. That particular section cannot be collectively bargained. So it establishes a statewide to preempt the FOP from having contracts that collectively bargain discipline in a way that gets rid of community oversight. And then lastly, and that's particularly important, is there's a clause that enables jurisdictions to establish an oversight body that engages in oversight and discipline, that gives them the power to do so. And a part of, for us, why it's not a requirement is because, as you and I know, as people who have been a part of building institutions, that you want to make sure, different jurisdictions have different mechanisms of government. And so we want to make sure that the community is involved in a co-design process where it works with the mechanisms of governance that exist in each jurisdiction, but still gives community power. So those are the three major aspects of what we put forward in terms of replacement language that both provides officers with due process, but provides mechanisms for community to exercise power over discipline and oversight law enforcement. So that's really the major summary of the bill. You want to say something?
Yeah. So that's a lot. I just want people to remember, when we talk about trial boards, we're not talking about a legal proceeding, so they're not being charged with a criminal crime. This is all about the internal proceedings about whether they get fired or not.
And matter of fact, you attended a trial board, right?
Exactly,
so talk about that.
So the very fact that we're calling that they even get a trial is kind of crazy, because regular people, when they're accused of a crime, they don't get a trial. They just have their boss make a decision. So other public employees have a process, but the police have a whole separate process that they call a trial. That, again, I'm one of the very few people I imagine that's actually sat through the entirety of one of these administrative disciplinary hearings, what they call a trial board. And this was after the cops with the Freddie Gray incident went through that criminal case. Of course, they were not criminally convicted. That was a separate administrative trial board. And I went to the one for Porter, the van driver. Every day I was there. And it's hard to overstate how ridiculous this was in the idea that you were going to get any justice from this process. So anyone defending a trial board, I would almost guarantee have never been to a trial board, have never sat to a trial board. Because what happens is that, first of all, when you think of a trial, you think one side represents the people, one side represents the defense. There is no side representing the people at a trial board. You have internal affairs versus the cop defended by the police union. So you have the police arguing against the police, basically. There is no space for the actual public opinion to be interjected. The only thing they're deciding is if they violated administrative protocols around procedure, and the only people making the decision are other police officers. And when you have this setup, it really doesn't matter who is making the decision. There is such a power imbalance between the police union and internal affairs. And internal affairs, again, they have no real public accountability. It's literally the police internal affairs department. Even if they did, the police union has so much more resources and so much more ability to defend the cop and to shape the discourse of the trial that it made me realize the trial board was inherently broken. So the police union, of course, is very well resourced. They were hiring independent investigators. They had independent video packages. They had PowerPoint slideshows. And hearsay is admissible in a trial board, which is not admissible in the court of law. So hearsay is just, what did Sally tell you? Sally's not in the court. Sally's not under oath. Well, Sally told me X, Y, Z. And if hearsay is admissible, I'm not saying that they are lying all the time, but if hearsay is admissible, you can just make stuff up. When I was in the trial board, the people defending Porter were literally saying things like, well, if he had seatbelted Freddie Gray would have bit him. And they showed a video that they claim was a month before Freddie Gray of what they claimed was a person in a van biting a cop. And it's like, this is prejudicial. This is ridiculous. And they literally showed a cop with a bite mark on their arm. And I don't know if that was actually a real cop. I don't know if that was actually in the BPD. All of these questions, you get no objection, Your Honor. You get no cross-examination. You get nothing. This is what a trial board actually is versus the mythology that anyone would tell you that it is. And on top of all that, again, when these folks are coming in, these are cops from other jurisdictions. They don't know anything about Baltimore. So they were basically able to portray Gilmore Homes as this dangerous reservoir of potentially violent individuals. So anything they did to get Freddie in the van as quick as possible was justified. And that was part of the reason Porter wasn't fired. So when that is the reality of what this trial board mechanism is, there's really nothing you can do to make that a legitimate mechanism I could tell someone in Baltimore to trust. And that's the whole point of this, is to build mechanisms that actually have bottom-up accountability. Now, conversely, the chief of police is politically appointed. So if we apply pressure to the mayor, they know that if we are against the decisions of the chief of police on these critical decisions, that's going to impact them politically. We don't have that leverage over the leader of the FOP. We don't have that leverage over the leader of internal affairs. And you need a clear target to, again, trust that bottom-up political pressure will be the mechanism of enforcement. And that's what I think the chief does that the trial board can never do.
And so a part of what we've been dealing with, again, we presented our bills, and Senator Carter, who's the Senate sponsor for SB 627, is the Senate sponsor for our bill. And, the coalition has been very involved in helping to structure the substance of our bill, which is essentially what you and I have been discussing. And, one of the things I think is important to contrast is some of the bills that have come out of the speaker's bills on the House side. For folks who, have just kind of been following along, that there was a work group convened by Speaker Adrian Jones, who appointed Delegate Vice Chair Vanessa Atterbury to chair the work group. And they came up with a series of recommendations that would, essentially were formed into the speaker's bills. And while in concept, much of the speaker's bills address in concept some of the things that, the coalition and us have been working on, some of the substantive things are things that contrast starkly with what we have proposed in terms of what the legislation should do. And there are really two major pieces. And again, we'll focus particularly on the LEOBR, which is House Bill 670. That's the speaker's bill. And there are two particular issues that I think are really cut and dry that I think are important contrasts. One is that it maintains the trial boards. Mm-hmm. Now, again, it does mandate in the bill a third representation of civilians on the trial board, but it still maintains those trial boards. And what it does is actually sets like a criteria or a rubric for certain things that police or police departments can structure in terms of the disciplinary process, but allows counties to make their own determinations. But it does still require trial boards to be a part of that process. So everything that you just mentioned, just about the inherent flawed nature of having a trial board in this process anyway, is in the speaker's bill. And the other is the piece around the authorization of an oversight body that has real power. So when we look at the Civilian Review Board in Baltimore City, one of the things that many people have complained about over many years is that it doesn't have any real power. And so for us, a part of this piece being in the bill has been about having a mechanism that actually gives the community power. And in the Speaker's bill, it talks about the establishment in every jurisdiction of an independent agency that does oversight, but doesn't specify its powers, which in that case, for me, it would mean that it won't have the power to have oversight and discipline as it's spelled out in Senate Bill 627. And so that's really the contrast between the two bills. And so I want to say that to say that I think a part of the contrast, it goes back to the framing we talked about in the beginning, right? Folks for whom are legislating from the frame of the recognition of Black suffering and wanting white societal recognition of Black suffering as the basis for their advocacy. The whole kind of stop killing us, which is a good segue. One of the people that testified was the kind of star community activist witness for the speaker was DeRay McKesson. And, we've had a bunch of critiques about DeRay, that lots of people that have critiques about DeRay. What's interesting, though, is that this is an example where his support of the speaker's bill lines up perfectly with all that we've said about the difference in worldview and methodology, meaning that when we're looking at the issue of police brutality, you look at what DeRay has stood for, which is essentially stop killing us, right? When asked, what's the demand? The demand is stop killing us, which again is we want you to recognize our suffering, stop hurting us, as opposed to we want the power to levy consequences against those who harm us. Very different paradigms. That notion of giving the community power is the thing that the speaker's bill is least apt to do. Even though, again, I think it was an honest effort to address the issue. It's just a difference in worldview and methodology.
Yeah.
And I think DeRay being kind of their star activist witness is such a great example of that contrast. I mean, it couldn't land any more perfectly.
Yeah, and I just want to point out that, of course, those who are astute observers of local politics would remember when Jill was running for her Senate seat, DeRay did a picture and endorsement of her opponent, who, of course, was J.D. Merrill, son-in-law of Martin O'Malley. And the fact that DeRay would come out against the person who is widely recognized as the champion on this issue shows you that his politics is more oriented, again, towards recognition and like this theoretical national political theory where like we need good white people who recognize our suffering to be in power and help us. And that seems to me also reflected in the methodology used in the speaker's bill, where again, it's like having something is not always, I think it's a methodology of like, at least we have something. I won't tell you what the investigatory body is, but I can tell you what's going to be there, and you should trust me. And the reality is that when that's the approach and it's not clearly designated that it's a mechanism of accountability to the bottom-up methodology, then that becomes another tool for people to use to serve as that release valve, to serve as that valve to do the symbolic recognition, to do symbolic investigations, to do symbolic, well, he wasn't fired, but I can tell you he was in the wrong, public shaming sort of things. And that can actually be an impediment to further bottom-up grassroots change. And so again, I think you're right, you said it was in good faith, but the reality of understanding how power works shows the danger of that methodology and that approach.
Right. And that's the thing that, we're in a moment now where racial justice, social justice is becoming more of a mainstream thing. And a part of what has happened is you have a lot of people taking up issues that fall in the line of like racial justice, social justice, for whom their socialization and background in racial social justice is more about, again, trying to get folks to recognize Black people's suffering as opposed to power, building a power base as the source of how we deal with racial justice, which I think goes back to the notion of the lack of trust there is both in the humanity, the intellect, the integrity, particularly of working class Black people. One of the things that happened there have been work sessions all week. So people who've been watching LBS's, social media page, you've noticed that we've been posting essentially every day for the past few days about work sessions that have happened in the Senate Judicial Proceedings Committee. These are voting sessions / work sessions where the committee talks about a piece of legislation, they go over amendments, and then ultimately the goal is to pass something out of the committee. And so hopefully you all have been watching, hopefully you all have been watching some of these work sessions, because it really gives you an inside view of the perspective of those that are engaged in crafting this legislation. There's a guy on there, a Republican from Harford County, Robert Cassilly, who, he's actually kind of my favorite, because he says exactly what he means. Like, liberals and progressives have a tendency to try to be sneaky about it and, be kind of spineless. But Cassilly's straight up about what he believes, to the point where one of the places where there was the most resistance is on the authorization of this community oversight body. We actually have gotten some favorable testimony from the Police Chiefs and Sheriffs Association on our bill, and it's in their self-interest because it gives them more power. But the thing that both the FOP and the police chiefs and sheriffs don't like is the authorization of this community oversight entity. Rob Cassilly he refused to call it an oversight entity, called it a kangaroo court.
Which is, if you ever seen a trial board, that's a hopping mad, Joey in the pouch, full blown, I'll be drinking a Foster's beer kangaroo court. So that made me laugh. So I've seen a kangaroo court, my friend, and I just couldn't believe that. You defend a trial board by calling something else a kangaroo court.
And to me, it's fascinating, because that comment perfectly encapsulates what I think people generally think about the idea of working class Black people having an institution where they have power over an institution like policing. Like, it perfectly encapsulates the fact that for many people it's ridiculous. He's just, bold enough to say it. But I think that belief is something that animates so much, even those who are more on our side in terms of police accountability. I think what Cassilly is expressing is what other people believe too.
It makes me think back to the gun trace task force. I mean, you and me know that people on the street were talking about the cops selling drugs all the way back in 2016.
Right.
And it was hard for even me to believe.
Right.
But it's like, we know.
Right.
But these are just like regular people from Stantown, Winchester, don't have degrees, aren't lawyers, but they know. And then lo and behold, 2 years later, found out they were right whole time. And that is the element that you lose when you adopt this sort of top-down, we need the lawyers, the technocrat ideology. You lose the accountability to the people who actually have the knowledge to actually be a force that knows what's going on, but has the credibility to be a conduit to community that people actually trust. And again, this whole idea of independent investigatory power, it's exactly what you said. They don't trust it in the hands of regular people. They want it in the hands of, the Republicans want it in the hands of the police.
Right.
But the Democrats, I believe many of them want it in the hands of the sort of vetted, sort of top-down lawyer types that they trust, as opposed to regular everyday folks. And that is a recipe for the continuation of the status quo, essentially.
Right. So before we jump into questions, one of the things that I want to kind of wrap with on this part of it, because one of the things that we want to do is, we really want to make sure that, we're looking to have a conversation with the Speaker's office. We think that we should be able to come to some agreement about, what the ultimate package for the LEOBR replacement language is. We think that that's going to be vitally important in really addressing that. One of the things that has happened is that one of the new FOP talking points, and apparently this is a set of talking points that has been ramping up over the weekend, the past couple days. And the talking point is that, and in fact, and see if you can bring up the FOP's website. Apparently, I'm not sure if it's Baltimore, their new talking point is the LEOBR is what protects Black officers from discrimination.
They've been using that for a while.
And they've been ramping up over the past few days. And that's been one of the major talking points that the FOP has used. What's fascinating is, so I'll give you a chance to address it. One of the things that's fascinating is that when the LEOBR was constructed, the LEOBR in 1970, there were not very many black police officers at all on the force. So the notion that it was written having in mind black officers. In addition, and this is something we don't get a lot of time to talk about because testimony, we don't get enough time. LEOBR happens right after the Church Commission and the disclosures of the counterintelligence program, the collaboration between COINTELPRO, its targeted violent attacks towards the larger left and particularly black social justice movements, and their collaboration with local law enforcement, the way in which white nationalists kind of went into law enforcement, kind of as the civil rights movement was catching steam. So the LEOBR and law enforcement, their history aligns much more with the conservative right counter to liberation movements and things for black people. And yet it's just astonishing that now they're going with the playbook of get your black officers and talk about.
I mean, collective bargaining goes hand in hand, and the LEOBR goes hand in hand with the militarization of the police. So you have this war on drugs, militarization phenomenon that can only happen when police know they're inoculated from public accountability. And what the LEOBR does is sets a template that gets modeled all over the country for inoculating police officers from the actual public accountability for their actions. So whether they are infiltrating the Black Panthers and setting up Fred Hampton, as many of you saw this weekend in the movie Judas and the Black Messiah, or they're doing it here in Baltimore, or any of these heavy-handed policing tactics that come in vogue with broken windows and the war on drugs in the 70s, they can't happen without a structure, not just a feeling, but a structure that protects policing from public accountability. There are some schisms between the interest of the unions and the interest of the chiefs. And we're definitely not saying the chiefs are always already good people. But what we're saying is that you need to have public accountability in a place that actually has the ability to make change. So if you want to have policing that's representative of your community, you need a mechanism of power that allows you to actually get that. And that's what we're pushing for.
Mm-hmm. So I think this is what's on the screen. What Adam has on the screen is the FOP, urging for people to support the LEOBR. And one of their central messages is around, keeping them safe. A big part of what their narrative is that without the LEOBR, black officers, won't be safe. And the FOP is pretty notorious for using its base, which includes the families of officers, and the kind of centering their advocacy on the safety of, the person who's an officer and their family as the basis for, how they, advocate legislatively, which a part of it when we talked earlier about the way that people have elevated law enforcement, in a place in people's imagination as kind of above. There it is. Join us in keeping Maryland safe. So this is their strategy. Mm-hmm. You know what I'm saying? And it's just so fascinating watching the FOP use the strategy of black officers in a moment where we're talking about racial justice.
And let's talk about who has the juice in the FOP. Because they like to portray themselves as they speak for all officers. How do you rise up in the union? It's seniority. So if you actually understand the dynamics of the FOP, it's a lot of the older, old school drug wars. They have the juice in the FOP because they have the seniority. Mm-hmm. And there are a lot of younger, cops who are like, the FOP is kind of wild. I don't even really agree with all the stuff they do or say, but I can't say nothing.
Right.
So we know these are the real dynamics on the ground, but they'll use the images of young black and brown cops as if that's who they are.
Right.
Well, we know that the reality is it's far, far more complex than that, but they want to speak for everyone, and they want to weaponize the fear people have to support a political agenda that's, we cannot stress this enough. The Maryland LEOBR is far to the extreme in a national context. So they're not defending a moderate compromise status quo. They're defending a radical status quo. But they're trying to use this, this is what we need to protect our officers. Then why does almost no state in the country have anything similar? Mm-hmm. It's just, it's ridiculous when Maryland has, these deeper protections for cops than even typically states you would think would have these sort of protections, like Louisiana and Tennessee. Maryland's far out of step with the national logical center, if there even is one on this issue. Maryland just isn't that. Right. So you have to keep that in mind.
We got any questions that have come through the chat? Let's see what we got.
It's a little lag. So if it's popping up, give us a second.
If we're talking about police reform in Maryland, then what happens to the men and women who these corrupt cops sent to prison? Is that criminal justice reform in these talks free some of these people? So we certainly agree with that. I think part of the issue is that this deals with a different issue. So we're dealing with the process by which police officers are disciplined and the ability for community access as oversight. We were actually involved in an effort a couple of years ago. So I guess this is 2019, where we partnered with Delegate Eric Barron out of Prince George's County and the State's Attorney of Baltimore City, Marilyn Mosby. We worked together on a bill about vacatur, which was essentially to vacate, and it was really two parts of the bill. It was to vacate marijuana convictions, being that eventually it's going to be legalized pretty soon, and vacating the convictions of folks for whom their conviction was based on the testimony of corrupt police officers. And we weren't able to get the marijuana vacatur piece, but we were able to get the second piece. And there were a few thousand people whose convictions were vacated as a result, who have the potential for their convictions to be vacated as a result of that piece of legislation. There's still a whole lot more to be done in that regard. But that's certainly something that we'll pick more up in the future sessions to deal with that part of the police accountability work. So next question, let's see. And thanks for that question, Alonzo. Our good friend and comrade, Zakia, can you all provide your analysis of the hearings and amendments thus far?
I'll leave that to you.
Yep. So let me just start generally with some of the hearings. The hearings let me start with the hearings on the Senate side on our bill, on Senator Carter's bill, Senate Bill 627, the initial hearing when it was heard in the committee. Much of it are things that you would expect. I think one of the best moments in it was there was a period of questioning about, and you know what, this actually might have been on MPIA, but I think the bills were put together. There was a conversation around use of force complaints. And one of the things that was said was that it's clear the reality, the evidence shows that Black people are more prone to be experience violence from police officers than white folks. And again, Senator Cassidy kind of lost it. Was like, that's crazy. We got all these murders. So I bring that up to say that there's definitely moments where particularly Republicans will juxtapose, the issue of violence and homicide with the issue of police accountability. One of the things that we've actually said is that dealing with police corruption actually has the potential to help aid in public safety, and at worst can make it so that public safety outcomes for public safety don't get worse, because people already don't trust police officers or the police department. And if our if our pieces of legislation are able to get through, at the very least, it helps to chip away at least a little bit at the distrust that people have of law enforcement, which is one of the key things necessary to addressing issues of public safety. So that was that. In the House hearings were interesting. The coalition that I mentioned that we're a part of testified in opposition to the Speaker's bill. because the two things that we kind of named a few moments ago that were fundamental differences for us were so fundamental that's why we testified in opposition to those bills. And it's interesting that I think that the difference in the two, I don't know, got highlighted enough. We tried as much as we could to really contrast the two bills. And we hope to have more conversation about that. In terms of the Senate the work sessions and voting sessions, I advise people to go back and watch some of those sessions, because that's where you get the really in-depth conversation about what's been happening. There's a particular amendment that got amended onto the bill that we're not happy with. It's an amendment that puts the trial boards back on, but the trial boards are advisory. It's one police officer, 2 civilians, and they investigate the part of the process that investigate the facts of the case that the chief, in terms of handing down discipline, and they get to recommend discipline. We're not happy with that amendment at all, because again, we were trying to move away from trial boards. Again, luckily it's an advisory trial board, except for the findings of the facts, they get final say in that. But in terms of the discipline, it's advisory. So we're not happy about that. But the fact that it's an advisory board is salvageable enough that that's the bill that we still would want to come out of the committee. And then I would encourage people particularly to look at just how much resistance there was to the idea of non-police officers disciplining police. I mean, just the way that it gets characterized and how offended. There are a few people, Senator Bailey and Senator Jackson are former police officers who are on the committee. And then I mentioned Bob Casserly and then there's Senator Michael Huff, Republicans, who are staunch supporters of the kind of status quo policing. And just to hear them characterize the idea of non-police disciplining police officers, I mean, it's almost like it's an offense to them.
And again, it's completely divorced from reality. Just look at a trial board. These are cops. They are not experts in administrative labor law. And I can tell you, looking at them while they were hearing the facts of the case, they look like deer in the headlights half the time. These aren't judges. These are cops. So right now, they're the ones having to adjudicate this stuff, and they don't know what they're doing because they're cops. This is not their area of expertise. And again, I just can't state enough that any of the concerns anyone may have of this system, the current system has all those flaws magnified by this massive power imbalance of the FOP having all these resources to bombard other cops with propaganda in the midst of these trial boards. It's just a fundamentally broken system.
So we want to thank you all for being with us. We're going to provide some updates soon about what happens with the policing bills. We didn't talk about Anton's Law, which is a bill that we're supporting around opening up police investigatory files to the public. We're going to talk more about that at the next podcast. We wanted to just dedicate time to the LEOBR. It's such a complex piece of legislation with so many different parts. We wanted to make sure that we made time to go in depth on it. But look out for our advocacy on the Maryland Public Information Act. And I'll just briefly say that, currently police investigatory records are prohibited from public information requests. And so what that does is that we don't then have the information about the kinds of abuses that law enforcement is doing against the community. We've only been able to get information in Baltimore City through the Department of Justice report when they did the investigation in 2016, and they found a pattern and practice of discrimination and discriminatory practices of the police department that we otherwise wouldn't have found out about. And then, of course, the Gun Trace Task Force, where there were new disclosures that happened about what the police were doing, that the Maryland Public Information Act amendments that we're advocating for, which would allow us to see not just the files of officers of the department saw fit to discipline, because that's what they're willing to give us. We don't just want those. We want the files that the police chiefs and the departments did not think require any action, because as the community, we want to be able to serve an oversight function and making sure that they're spotting patterns of police misconduct and brutality. And that just gives the public a mechanism to check the police chiefs on the departments. So that's something that we're going to be focusing a lot more on in the next podcast, and that's a core part of our advocacy. Look out for action alerts on the Maryland Public Information Act, which is something that should come up for a vote relatively soon, and continue. One of the things I want to make sure I emphasize actually before we go, some people ask the question, does calling and emailing the legislature work? And we want to tell you all that, LPS being an independent Black organization, right? We're not an appendage of any corporate entity, not an appendage of a foundation or a major nonprofit. We are an independent Black grassroots organization. And the fact that when we put up action alerts that people call the legislature, it gives us the kind of leverage that makes them have to respond to us. So if you all don't, reach out and pressure them, they don't respond to us. They don't care. But because they see the level of response we get when we ask people to call and email, it makes a big difference. So when you see the action alerts, continue to call, to send emails, to put pressure. It's really the only real weapon that we have when we're doing work in Annapolis. So continue to do that. Again, I'm Dayvon Love, Director of Public Policy, Leaders of a Beautiful Struggle. This is my man, 100 Grand, Lawrence Grandpre, Director of Research for Leaders of a Beautiful Struggle. You all have a good night. Safe travels. Peace.